A portrait of a distinguished-looking jurist hangs in the county courthouse in Mayville, New York. He has a handsome face, graying hair, and a posture that projects strength and confidence. The tag on the portrait simply gives his name, Warren B. Hooker, and if you ask anyone who works in the building, they probably can't tell you any more than his name. But there is a story that goes with that name, and in 1905, anyone in New York State, or perhaps anywhere in the country, could have told you the story of Judge Warren B. Hooker. During the summer of 1905, the press and the public of New York State were abuzz about the hearings before the state legislature and whether Judge Hooker should be removed from his position as Justice of the Supreme Court, Chautauqua County. As the combined Senate and Assembly Judiciary Committees convened their hearing and called the roll, the handsome judge sat in an Albany restaurant, leisurely enjoying his lunch as if he had not a care in the world. His confident attitude, though infuriating to the committee, would prove to be justified. Warren Brewster Hooker was born on a farm in Perrysburg, New York in 1856. Although his parents were pioneer farmers who had moved to the rough forests of western New York from Vermont and Massachusetts, they were successful enough to see that their son was well educated. He attended public schools in nearby Forestville and then the Forestville Academy. After completing his education, young Hooker returned to work on the farm for a few years, then joined the law office of John G. Record in Forestville, where he read the law. In 1879, he was admitted to the bar and he practiced in the firm of Record and Hooker. His political career began early. In 1878, 1 year before he was admitted to the bar, Hooker was appointed special surrogate for Chautauqua County, a post he filled until 1881. His relationship with his law partner was close enough that Mr. Record pledged his 18-year-old daughter Nellie to Hooker in marriage. The young woman, however, had other ideas. She publicly stated that she would never marry Mr. Hooker, and over the 2-year engagement, the wedding was postponed several times. Finally, in November of 1881, the wedding plans were finalized and the invitations were sent out. The night before the ceremony, the headstrong young woman eloped with another man. The first minister they approached refused to administer the vows, so they found a horse and buggy and traveled to another town where the minister was more cooperative. The couple was married that night and returned to Forestville at midnight, where they checked into a hotel as Mr. and Mrs. Dye. How Hooker's misery became so public will never be known, but the Maysville, Kentucky newspaper reported the event in detail. It noted that Hooker took the news, quote, in a manly way and has the sympathy of the community. Shortly after his public humiliation, the 25-year-old Hooker did what many young men of the day did to heal a wounded heart. He left town and headed west in search of adventure. Hooker left Forestville and traveled to Denver, Colorado. There he met another young lawyer named James Ashton, who was also in search of adventure. Ashton was originally from Ontario, Canada, and had run away at age 11 to work on a cattle ranch in Nebraska. Eventually, his older sister convinced him to return to Ontario and finish his education. He not only finished his education, but at age 14 enrolled in law school at University College in Toronto. While in Denver, the two young lawyers became fast friends, and after a few months they left for the promise of San Francisco, roughing it along the way. Once in San Francisco, they heard of opportunities in the Puget Sound area and left for Seattle. In Seattle, they learned of Judge Roger Green in Tacoma, Washington, who was examining applicants for admission to the bar. They traveled to Tacoma, took the exam, and promptly were admitted to practice. They immediately began handling cases and realized that prospects were good and decided to stay. In 1882, Tacoma was a rough port town with few buildings of substance. The two young men, however, found plenty of legal work in the growing town and practiced together for 2 years. In 1886, Hooker traveled home to western New York for a visit. The visit became permanent, however, when he met a young teacher named Etta Elizabeth Abbey. She was the daughter of Chauncey Abbey, president of Fredonia National Bank. When Etta accepted Hooker's proposal of marriage, Hooker decided to remain in Fredonia. Hooker and Etta were married on September 11, 1884. He was 28 years old and she was 30. They settled in a home at 130 Central Avenue in Fredonia, just purchased for them by Etta's father. They had 2 children, a son Sherman and a daughter Florence. Hooker began practicing law and his practice grew and he was well known in the community. He was appointed town supervisor for the town of Pomfret in 1889 and 1890. Hooker's political fortunes were on the rise, and in 1890 he was nominated by the Republican Party to fill the House of Representatives seat for the 34th Congressional District, representing Chautauqua, Cattaraugus, and Allegheny counties. At the age of 33, he was nominated over far older and more experienced men of the party. Hooker handily won the election, and when he was sworn in on March 4, 1891, he was the youngest member ever to sit in the House of Representatives. Hooker's political star continued to rise. He was re-elected 4 times, winning handily. In the House, he was appointed chairman of the important Rivers and Harbors Committee. This powerful appointment allowed him to obtain federal funds for the Dunkirk Harbor in his home district. In 1898, Hooker's interest shifted away from Congress when New York's Governor Frank Black appointed him to fill a vacancy as Justice of the State Supreme Court in Chautauqua County. Hooker left his powerful friends in Washington and returned home, where the next year he was elected to a 14-year term. His achievements did not end there. In December of 1902, Governor Benjamin Odell appointed him to serve on the Appellate Division's 2nd Department in Brooklyn, New York. As a judge, Hooker was liked and respected. One historian relates the story of a young man Hooker sentenced to death on a murder conviction. The magistrate showed more emotion than did the defendant. The carefully restrained but distinctly evident sorrow of the judge, his pallor, his manifest sense of the tremendous and melancholy responsibility he was wielding left an impression. Afterward, Hooker granted that unfortunate young man a new trial. Although he may have been a good judge in many regards, Hooker unfortunately forgot that being a judge requires a different set of rules than serving as a congressman, and he continued his practice of using his Washington connections to help his former constituents. When his 16-year-old nephew Maurice was attending Fredonia Normal School and needed a job to support himself, Hooker contacted a friend in Washington, D.C., and secured a position for Maurice at the Fredonia Post Office. When his wife's niece similarly needed a job, Hooker secured a postal position for her as well. Then there were others. Mrs. Hooker had a business partner in a failed oil exploration company in West Virginia. He had signed a note to the Fredonia National Bank, which Mrs. Hooker co-signed. Hooker secured a post office job for him so he could repay the note. Even Hooker's groundskeeper was awarded a position. At one point, the Fredonia Post Office, which employed 4 full-time clerks, had 6 additional appointees of Hooker's on the books. The jobs, however, were classic graft. They were no-show jobs. Not only did the appointees fail to provide any services, but the salaries were exorbitant. Hooker's nephew Maurice, only 16 years old, was awarded a laborer job for $600 a year, which previously had been filled by a scrubwoman at $12 per year. A young woman named Catherine Clark was hired as a clerk at $400 per year, and at Hooker's urging was awarded successive raises over 3 years until she was earning the unheard-of sum of $1,000 per year. Another woman was awarded a position with the Fredonia, New York Post Office, even though she lived in Washington, D.C. and could not appear for work even if she wanted to. the scandal surrounding the no-show jobs eventually broke, the United States government ordered the Fredonia postmaster to repay the fraudulent salaries. When he asked Judge Hooker for advice on how to handle the matter, Hooker unhelpfully advised him, "Do as you think best." And the post office scandal wasn't the only one. It appeared that Judge Hooker might have used his influence as a justice of the Supreme Court to secure a favorable ruling on a case in which he had a personal interest. It stemmed from a lawsuit relating to the Stearns building in Dunkirk. Today, the Stearns building is connected to the City of Dunkirk Municipal Building, but in 1902 it was a separate building. Hooker and his business partner and fellow attorney, Lester F. Stearns, had built the new state-of-the-art office building and leased the majority of it to the United States Postal Service for a rent far above market rate. The modern building, which has large windows and plenty of light, had been built so close to the city's property line that the cornice of the building extended over the line. To protect their building, Hooker and Stearns obtained a light and air easement from the city of Dunkirk. No sooner had the city council approved the easement than a disgruntled taxpayer and political rival of Stearns filed a suit to restrain the city from granting the easement. Despite the fact that offices had telephones in 1902, Hooker personally visited the Honorable Truman C. White in Buffalo and asked him to hear the case. No doubt Hooker felt comfortable approaching his colleague, who, like Hooker, had been born in Perrysburg, New York, and was a staunch Republican. White scheduled the matter for trial on January 21, 1902, but the city of Dunkirk was not notified of the date, even though it was a party to the action. Assured that the matter was essentially settled between the parties and that there would be no opposition at trial, Judge White had the testimony taken before his stenographer and did not listen to the evidence. He signed findings of fact and conclusions of law drafted by Hooker and Stearns' counsel without even reading them. It was no surprise that Hooker and Stearns won the litigation, but it was a shock that the final order completely prohibited the city of Dunkirk from building on its own property. 2.5 years later, as the scandal erupted, Judge White vacated the outrageous judgment to protect his reputation. Political patronage had long been a fact of life in American politics, but that was beginning to change in the first decade of the 20th century. By 1903, the public was growing intolerant of business as usual. As talk circulated about Hooker's acts, the recently formed Jamestown Bar Association began an investigation through its grievance committee, spearheaded by JBA President Frank Stevens. Although not anxious to investigate a powerful local judge, the Jamestown Bar Association grew concerned about the public perception of the judiciary when Hooker failed to deny or otherwise answer the allegations against him. The Jamestown Bar Association held 4 days of fact-finding hearings on the matter, and in January of 1904 forwarded their complaint to the New York State Bar Association for further action. The New York State Bar Association, in turn, forwarded the matter to the Judiciary Committee of the Assembly of the State of New York. In early 1904, the Judiciary Committee of the State Assembly agreed to jointly investigate the Hooker matter with the Senate Judiciary Committee. Neither body had ever been asked to remove a sitting judge before, and the committee struggled with difficult legal and procedural issues. Could a Supreme Court justice who had not been convicted of a crime be removed? Did removal of a judge, even for corrupt, self-serving behavior, erode the independence of the judiciary? Could a sitting judge be removed for improper acts committed that were not committed in his capacity as a justice? As the legislature struggled with these legal and philosophical issues, the public howled for blood, and newspapers across the country covered every step of the hearings. Through the spring of 1905, the Joint Committee investigated the allegations. Despite some lingering uncertainty, on May 1, 1905, the committee issued a unanimous resolution that Justice Hooker was unfit to serve and should be removed from the bench. The hearing for Hooker to answer the charges was scheduled for July 1905. The hearings were held in the Assembly Chamber at the state capitol in Albany. Hooker was represented by William G. Laidlaw of Ellicottville, New York, and Arthur C. Wade of Jamestown, and several other attorneys. Laidlaw was a Scottish immigrant and a former congressman. Wade was a brilliant trial attorney who was well known for securing a new trial in a difficult spousal murder case. He had obtained an acquittal in that trial. The prosecutors were Henry B. Coman for the legislature and Frank Stevens for the Jamestown Bar Association. The indictment contained 5 allegations of fraud with regard to the postal appointments and 1 count in relation to the fraudulent judgment against the city of Dunkirk. The issue of possible bribery on behalf of the Delaware and Hudson Railway Company was deemed tangential and was disregarded. With everything seemingly aligned against Hooker, the future might have seemed grim to a man of lesser confidence, but to Hooker it did not. One state legislator had predicted, "Hooker is safe," which proved to be just the case. July 1905 was swelteringly hot, and the hearings, which under other conditions might have been highly charged and dramatic, were instead tedious and dull. Testimony from prior hearings and reports was read into the record, with lawyers taking turns reading the parts of witness and attorney. At one point, the question, "Are you a married woman?" was read, and the male attorney reading the answer replied, "I am." The New York Times noted that this exchange would normally have produced great amusement, but it was so hot that the only response the audience could muster was a feeble smile. On July 11, 1905, 2 legislators from western New York were so miserable in the heat that they created a minor scandal when they removed their heavy black frock coats and sat in their suspenders and white shirts. They were immediately ordered by the lieutenant governor to keep their coats on. Attendance fell as legislators took rides on trolleys and in automobiles to escape the heat of the Assembly chamber. The New York Times called the state capitol building a $26 million stone pile, which exemplifies that money does not mean ventilation. It complained that the Assembly chamber felt like a Turkish bath. So few legislators were willing to sit through the hot, dull afternoons that often there was no quorum. The New York Times wrote, "The hearing appears to be on the order of a farce. Only 26 senators and 50 assemblymen were present today in Assembly Chamber. About 20 followed the testimony. The rest were talking or dozing." This led the paper to wonder, quote, "how all the individual legislators are to pass intelligently on the case, when as a rule, not half are present at the hearing. It is one of Albany's greatest mysteries." Hooker testified in his own defense. Also testifying for him were his wife, Etta, Justice White, his partner Lester Stearns, and more than 12 other witnesses. Hooker's counsel argued that Hooker was not responsible for the no-show employees at the Fredonia post office, as he would not have known whether they were actually reporting for work or not. In an uncharacteristically blunt approach, his attorneys argued that Hooker was simply doing what politicians do when he obtained the appointments. They pointed out that the city of Jamestown had been happy enough to use Hooker's influence when they needed a new federal building, as had the city of Buffalo when he assisted it with obtaining $600,000 in federal money for a new breakwall for the harbor. Hooker's attorney, John E. Stanchfield, argued, "It was a great, and noble act because it helped these localities. They had benefited by his influence and power. But when he tried to help some poor, lonely fellow that had helped him in climbing the ladder of political fame, and whatever else he may be, he is not one of those men who have climbed into power and place over the dead body of a prostrate friend. It was a different proposition. He is one of those who has stood by the guys who carried conventions that elected men to office, a practical man in practical politics today, and I do not believe that the legislature of New York will condemn a man who has won success along those lines." When the handsome 48-year-old judge took the stand, even opponents had to admit he made a good impression. Hooker admitted that he had made the recommendations for the appointments to the Fredonia post office, but he pointed out, "Many of a congressman's constituents regard him as an errand boy between them and the departments. It was general practice for congressmen to recommend constituents for appointment to the post office." He explained that he had not inquired whether any positions were in fact available and that he did not know the appointees were not reporting to work. When prosecutors asked him if he would characterize the no-show appointees as criminals, he said, "These people are neighbors of mine. I don't like to characterize them as criminals." By July 20th, 1905, the hearing had concluded. Because the Assembly Judiciary Committee had initiated the proceedings, the Assembly voted first. As one observer pointed out, this provided the Senate with excellent political cover, as it would not have to vote at all should the Assembly vote against removal. The Senate's hopes were realized when the resolution to remove Hooker failed by a margin of 10 votes. As predicted, Hooker was indeed safe. The public reaction to the vote was angry and swift. One observer noted, "A few years ago, Governor Theodore Roosevelt removed from office the county treasurer of Chautauqua County for receiving a present of $100 from one who had been benefited by the exercise of his official discretion. A higher standard should not be applied to the acts of county treasurer than to those of a Supreme Court justice." Papers published a political cartoon illustrating the difficulty of removing a sitting judge in New York, even with a crane. The New York Times, a staunch critic of Hooker, referred to him as a moral imbecile. The paper editorialized, "A man capable of these acts falls far below the common standards of decency and honesty that all right-thinking men ought to agree that his presence on the bench would be a shocking public scandal." The New York Times argued that the political machine had protected Hooker. Warren B. Hooker has been so deeply concerned and implicated with Benjamin B. Odell in the mysterious process of the Republican machine politics up the state that from the beginning of all the proceedings, powerful influence have been at work to save him from disgrace. While one might think that a scandal of this magnitude would mar a man's future, that proved not to be the case for Judge Hooker. He served out his term on the bench of the Appellate Division and returned to his successful private practice in Chautauqua County in 1913. Back in Fredonia, Hooker was socially active, both at Trinity Protestant Episcopal Church in Fredonia and in the Forest Lodge of Free and Accepted Masons. He had several business interests, ranging from a mortgage loan business to the production of sand glass in Pennsylvania. Hooker's famous luck again protected him in 1909 when he escaped near death in a serious train wreck near Utica, New York. Although 2 people were killed when the train derailed, Hooker survived after being trapped in the wreckage for several hours. In 1919, Hooker returned to the bench when he was appointed court referee in Chautauqua County Supreme Court. He served in this post until his death in March of 1920. In fact, he had just presided over a trial in Allegheny County the 2 weeks prior to his death. Hooker died on March 5, 1920, at the relatively young age of 64. He and Etta, who died in 1942, were buried at Forest Hill Cemetery in Fredonia in the Hooker Abbey Sessions family plot. Hooker was a product of his times. Rising from a humble beginning on an upstate farm, Through education, hard work, and personal magnetism, he built a substantial presence both statewide and nationally. His methods of rising to success were the tools of the times as well. Political favors, nepotism, cronyism, and graft were, if not acceptable, at least overlooked when Hooker started his upward ascent. By 1905, however, the progressive movement that had started in the 1890s had reached its nadir. While muckraking journalists challenged societal ills and Theodore Roosevelt broke up trusts, society demanded more efficient and less corrupt leaders. One historian wrote, "His was a day of personal politics, and it was necessary to success that a politician maintain a strong organization loyal to him. This Judge Hooker early learned, and he proved one of the strongest leaders of organized politics in his district. He fought his own political battles according to the rules laid down by former leaders and by contemporaries. He asked no quarter and gave and received hard blows with equal equanimity." Despite Hooker's misdeeds, which are so shocking to our modern sense of ethics, history's been kind to Warren Hooker. After his death, Hooker was remembered this way. "It has been said of Judge Hooker that he served his friends too well, but it is the testimony of all the attorneys who practiced before him that he was one of the most impartial judges who ever sat in New York courts. Loyalty to his friends was a striking characteristic of his whole life, but a friend was never recognized as such in his judicial hearing. While he was a politician of the most astute type, he was also the gracious gentleman, the just judge. Those who knew him best loved him most, and as a friend and neighbor, he will long live in the hearts of his townsmen. They will remember that his long public career was marked by countless favors to those who were less fortunately situated."